with the rate at which these herdsmen are really killing and taking, the lives of people and doing all sorts of things and even taking laws into their hands, I think it's high time the government declare them as terrorist groups because they seem not to be really stopping. And, court is even set to deliver judgment, against these guys. And it's really, it's high time that they really face the law. But I don't really know if this present administration, this present government is really ready to take the bull by the horn and even stand to, fight against this Fulani headsman. Like a lot of Nigerians will say that because the president is a Fulani, that he does not want in any way to declare them as terrorist group. Imagine how these terrorists or these Fulani guys go about with rifles, heavy rifles, hiding them, making them look like they are sticks, and killing people often on a daily basis. In fact, taking over communities and other stuffs. This has got to stop and should not be encouraged in any way. Because now that Sunday Igboho is just a man, how long can he really continue with this kind of fight? Because with all of this happening, I can assure you that there are people in politics, there are people in this present government that are involved with these Fulani headsmen, that are even protecting their interests to make sure they continue what they are doing. Remember that everything that happens in Nigeria always have an ulterior motive. They always have a motive behind whatever they are doing. So some of these guys that are involved in this are politicians. Some of them are in Buhari's administration. Some of them are the ones sponsoring Boko Haram, let alone herdsmen. So really, I think it's high time these guys are taken to court and let judgment be served to them. Well, the what we have for you today is actually about a report about this Fulani herdsmen and the killings, because Ecowas court is set to deliver judgment in Serap federal government's case. Yes, let us get into these details and see all that is right here. But before then, please, if you have not subscribed, please do, and also give this video a thumbs up, and don't forget to hit the notification bell so you get updated anytime we drop a new video. All right, guys, without wasting much of your time, right here it says that the ECOWAS Court of Justice, Abuja, this morning heard arguments in the case brought by Socio-Economic Rights and Accountability Project SERAP against the federal government, seeking justice and accountability for the authorities' failure to prevent, account for the investigate killings, raping, maiming of Nigerians and other residents, and destruction of property across the country by herdsmen and other unknown perpetrators. The court adjourned the suit to 22nd April 2021 for judgment after hearing arguments from solicitors to Serap, Femi Falana's son, and the government lawyer Mr. Adebayo Ogundele. In the suit number ECW-CCJ-APP 15/16, Serap is arguing that the continued killings, attack, raping, maiming of Nigerians and other residents, and destruction of property by the military, police, herdsmen, and other unknown perpetrators across the country amount to serious violation of human rights, of the rights of life, to the security and dignity of the human person, and to properties. Femi Falana, arguing the case, said the government has not denied the serious averments by Serap. The government is responsible for the unlawful killings by herdsmen and other unknown perpetrators which have not been adequately prevented, investigated, or prosecuted by the authorities. These responsibilities are heightened when an observable pattern has been overlooked or ignored, such as is the case in this suit. Falana also argued the government has a responsibility to protect and ensure the security of life and property of everyone in Nigeria. It is not enough for the government to say that civil cases have been brought by some of the victims. The government has a responsibility to investigate, fish out the perpetrators, and persecute them, and to compensate the victims. The suit reads in part, Serap also contends that the obligation to secure the right to life is not confined to cases where it has been established that the killings were caused by an agent of the state, nor is it decisive decisive whether those affected or their families have lodged a formal complaint about the killings with the competent investigatory authorities. It is contended that the mere knowledge of the killings by the military, police, herdsmen, and other unknown perpetrators on the part of the authorities have ipso facto given rise to an obligation under Article 4 of the African Charter on Human and People's Rights to carry out an effective investigation into the circumstances surrounding the killings and to identify the perpetrators and bring them to justice and to provide reparation to victims. Moreover, the defendant has a responsibility for those killings, raping, maiming, destruction of property where authorities knew or ought to have known of an immediate threat and failed to take measures that might have been expected to avoid those attacks and killings. Serap further contends that the defendant has positive obligations to provide a framework of security for the protection of life and to protect the lives of those individuals at risk from unlawful attacks by the military, police, herdsmen, other unknown perpetrators. The lack of accountability for the attack by the military, police, herdsmen, and other unknown perpetrators across the country has continued to create a culture of impunity which clearly is not compatible with the rule of law in democratic society. Serap contends that the defendant has a positive obligation to take measures to secure the right to life, right to security and dignity of human persons, right to property, and to prevent attacks and killings by military, police, herdsmen, and other non-perpetrators across Nigeria. Human life has a special value and dignity which requires legal protection. It should be pointed out that those affected in the present case include the most disadvantaged and vulnerable sectors of the society. A fundamental notion of contemporary human rights law is that victims of violations enjoy an independent right to effective remedies. This idea is itself founded on another long-standing legal principle, ubius ibi remedium. There is no right without a remedy. Serap, therefore, is asking the Ecowas Court of Justice for the following reliefs: a declaration that attacks, killings, and raping and maiming of citizens and other residents, and destruction of property and other serious human rights violations and abuses across the country by military, police, herdsmen, and other unknown perpetrators amount to failure by the defendant to exercise due diligence to prevent the attacks and killings, and cannot be justified under any circumstances, and therefore constitutes a serious breach of Nigeria's international human rights obligation commitments to ensure and secure the rights to life, to dignity and security of the human person, and to property guaranteed under the African Charter on Human and People's Rights and the UN International Covenant on Civil and Political Rights, to which Nigeria is a state party, and so on. More declarations by Serap to WHO. Well, obviously, we all know what has been going on in the country and should not be continued because the government has not been responsible. So, guys, what do you think about this? Please drop it in the comment section and also give this video a thumbs up. Do have a pleasant time. Bye for now.